Good morning, and thank you for joining us for this BVI Finance Breakfast Forum. I am Elise Donovan for BVI Finance. Today, we are very pleased to be joined by a very distinguished panel of speakers from the BVI Financial Services Commission. They are going to talk to us about the regulatory updates in the financial services industry, as well as the amendments and other relevant legislation. We have the pleasure of having the Managing Director and CEO of the BVI Financial Services Commission, Mr. Kenneth Baker. We also have the pleasure of having the Director of Policy Research and Statistics, Mr. Cherna Jallo, KC. And we also have the rare pleasure of having with us the Director for the Registry of Corporate Affairs, Ms. Myrna Herbert. I thank them both, and just some housekeeping notes. We'll start the presentation or the discussion, and then later on we'll open for question and answers. So continue to put your questions and answers in the Q&A section, not the chat. Please put them in the Q&A section. We are so pleased to see so many of you. I think we are now at about 200 strong. So it's very good to see such a strong turnout in this webinar this morning. I would like to start with giving you a little bio or background information on our very distinguished panel speakers. Mr. Kenneth Baker was appointed the second Managing Director and Chief Executive Officer of the Financial Services Commission in February 2021. As the Managing Director and CEO, he is responsible for the administration and operation of the Financial Services Commission. His responsibilities include regulating the BVI's financial services industry, the development of new service and product offerings aimed at developing and enhancing the attractiveness of the BVI as a situs for legitimate cross-border financial services and liaising with government and private sector stakeholders in pursuance of this objective. Mr. Baker's track record spans 37 years in the banking and financial services sector. He joined the Financial Services Department in June 2000 as the Inspector for Banks and Trust Companies after a private sector career in banking. He was appointed the Deputy Managing Director Regulation in April of 2005 and jointly held the position Director Banking Insolvency and Fiduciary Services Division. We also are joined by Mr. Cherna Jallo, KC. Prior to his appointment as Director of Policy Research and Statistics at the Financial Services Commission, he served as the Attorney General of the BVI from 1999 to 2007. And prior to that, he served as the Parliamentary Counsel in the Attorney General Chambers from 1995 to 1999. Mr. Jallo played an instrumental role in the development of a number of financial services and related legislation, including the Financial Services Commission Act of 2001, which formally established the Financial Services Commission. He is a member of the Gambian and BVI Bar Associations, and he's responsible for numerous financial services legislation beyond the Financial Services Commission Act. We also, as I said, have the rare pleasure of being joined by Ms. Myrna Herbert, who's the Director of the Registry of Corporate Affairs. Mrs. Herbert was appointed the Registrar of Companies in 1998 after serving as Deputy Registrar for 3 years. Prior to her appointment as Registrar, she had a long public service career. She was appointed Director, Registry of Corporate Affairs on the introduction of the Financial Services Commission in 2002. I am so pleased that we are able to have these distinguished speakers with us to give us all the information on what is happening with the Commission And I am going to invite them now to open their mics. And Mr. Baker, I think you are up first. Please welcome Mr. Baker to the podium. And Mr. Baker, we have 243 persons in this seminar this morning.
Okay, thanks, Elise, and certainly thanks for the invitation to participate in this BVI Breakfast Forum. Now, for the Financial Services Commission, 2022 has been certainly a challenging year and a busy year on the legislative front. So we started off the year in January by an amendment to the BVI Business Companies Schedule of Order 1, which is essentially the fee schedule for the Business Companies Act. And then around mid-year, we conducted public consultation on the BVI Business Companies Act. This consultation resulted in the enactment of the BVI Business Companies Amendment Act of 2022 in July of 2022, as well as the BVI Business Companies Amendment Regulation 2022. Mr. Jallo will go into more details on these amendments when he speaks. Then later in August, we also money laundering, terrorist financing amendment code of practice and the anti-money laundering, terrorist financing, anti-money laundering regulations were also enacted in August of this year. Then in October, the BVI Business Companies Amendments Schedule 1 or number 2, the order, which is essentially the fee schedule again, was further amended, in this case, to increase the incorporation and the annual fees for BVI business companies. That was done in October, but the fees will take effect from January of 2023. Here will be rounded out by an amendment to the Financial Services Fees Amendment Regulations 2022, and those fees will take effect from April of 2023, and those essentially will amend the regulatory fee schedules for next year. We recently concluded a public consultation on Virtual Asset Service Providers Act 2022, and it is hoped that this piece of legislation will be enacted before the end of this year. There are a host of amendments we propose for next year, but those will be outlined in the budget address later this year. So with those introduction of what legislative changes are for the year, I turn it over to Mr. Jallo, who will go through the amendment to the Business Companies Act. Thank you.
Thank you very much, Mr. Baker. Mr. Jallo, we now ask you to open your mic. Your mic is already open. Please go ahead.
Yeah, thank you very much, Alice, for the kind introduction. And thanks, Ken, for that introduction. And I join in welcoming all the participants to this dialogue. And I say dialogue because it's supposed to be a discussion so that we all have a better understanding of what the new BVI business companies regime as amended is expected, not only to look like, but to function as well. And feel free to ask questions. We by no means feel that everything is perfect, but at least we have something we believe we can work with. You will recall that the amendments to the BVI Business Companies Act has been the subject of discussion for nearly 2 years, if not more than 2 years now, beginning with the policy proposal that was rolled out for the industry to consider and express opinions on. And we did receive quite a number of opinions on that subject matter. And with the help of the Company Law Review Advisory Committee, we were able to chart a way forward in terms of the policies to adopt in shaping new amendments to the BVI Business Companies Act. And when we framed the amendments, these were rolled out as well. If you hear some background, I'm sorry, it's on the outside. I really don't know what's going on, but hopefully that will be taken care of shortly. So the amendments were rolled out, inviting comments, and as before, we did receive quite a number of opinions on the draft. And we again looked at those, shared them with colleagues in the Company Law Review Advisory Committee before we were able to finalize the draft. And subsequently, this was approved by Cabinet and then enacted by the House of Assembly. The BVI Business Companies Act is complemented by the BVI Business Companies regulations. Both have been amended in order to ensure appropriate synergy between the two instruments and also make clear in terms of what is expected to occur come 1st January 2023, that being the date when these new enactments will actually take effect. Now, there are quite a number of areas to cover in terms of the legislative changes that have been effected to the BVI Business Companies regime. And I will outline them in terms of subject matter to you. Those of you who were privileged to attend the Association of Registered Agents FSC workshop a while back, this might be repetitive to you, but nonetheless, I'm sure you're wiser and perhaps able to better aid the process in terms of the dialogue we will be embarking upon shortly. Now, I will deal with the subject matters as I indicated earlier. The other amendments to the regime are merely streamlining provisions, consequential changes that needed to be made as a result of making certain key amendments. So I will not go into those minute details, but in any case, anybody can feel free to raise questions if you have them in relation to those matters. Now, I will now, at least with your permission, delve into the new elements comprised in the BVI Business Companies Amendment Act and the regulations. Now, before I do that, I just need to point out one fundamental element, which I will come to later on, which has to do with the filing of annual returns by BVI business companies. But I will deal with that in greater detail later on. But just to make the point that that particular legislative measure is still being worked on, it hasn't been finalized. We did receive quite a number of helpful comments on it. But the Commission felt that further dialogue needs to be had on it. That is why we have that delay. But we hope to have it in place as soon as possible. But I will speak more to that later on. Now, beginning with bearer shares. One of the key areas outlined in both the policy document and in the amendments has to do with the abolition of bearer shares. As you will all recall that this has been a very topical issue among standard setters globally. And whilst the position had always been accepted that if you immobilize bearer shares, that was fine. But increasingly, the opaque nature of bearer shares has taken center stage globally and is creating a problem. But alongside that is the whole issue of the structure of companies. What really does it mean? And I will come to that as well, but just to make the point that it seems that the whole notion, the whole concept of a structure of company, whilst it is clear to most of us, it is not clear to others. And what makes it unclear to others has to do specifically with the issue of who has responsibility for AML CFT records when a company is in a structure mode. Which means it is active, it cannot legally do anything, but it is alive. So what happens? So there were those issues. And we thought that the best thing to do was to revisit that regime and have it completely revamped with a view to ensuring better clarity and also to facilitate future assessments of the jurisdiction, but more about that later on. But coming back to bearer shares, what we proposed was to eliminate this particular regime. And not that many companies were really involved in the business of issuing bearer shares. And we thought that the best way of getting around this is really to abolish bearer shares. And much to our pleasure, I must say, because the industry really made this very easy for us. Everybody agreed. I can't remember a single provision in our previous consultations where everybody was in agreement with a particular proposed measure. But this one, from all the comments we received, everybody was essentially in agreement that we should abolish the bearer shares. So amendments have been made abolishing the bearer shares, and provisions have been made in terms of how those bearer shares will now be transitioned into the new regime. And I will encourage all participants to look at the schedule, which is Schedule 2 of the BVI Business Companies Act, which has been amended to effectively deal with how those existing bearer shares will be dealt with come 1st January 2023. So that is as far as bearer shares are concerned. The other area where change has been effective has to do with the voluntary liquidators. And what we have done, we have redefined a voluntary liquidator more in terms of the residency requirement, which means that to be a voluntary liquidator, you must now be physically resident in the territory for a period of not less than 180 days prior to appointment. And but this will apply only in relation to liquidators or voluntary liquidators who are based here in the BVI. As I indicated, there is that physical residency requirement. It would not necessarily apply in a joint liquidation in part. And I say in part because in a joint voluntary liquidation, in a joint liquidation, basically the joint liquidator, if the person is resident outside of the jurisdiction, that requirement of physical residence will not apply, but obviously will continue to apply to the local resident voluntary liquidator. So that is important. So like I said, the existing voluntary liquidator, that is currently where we are at the moment. If prior to 1st January 2023, somebody has been appointed as a voluntary liquidator of the company, that process continues to operate under the existing regime, which means nothing changes. So the changes will only apply with effect from 1st January 2023 to somebody who is appointed voluntary liquidator from that date onwards. And what we have also done is to expand the pool of persons under the BVI Business Companies Act who may file notices for other documents to include a voluntary liquidator. And it is also important that we bear in mind that the Act provides a legal framework for establishing necessary qualifications and criteria, basically, or categories of individuals who may be qualified or eligible for appointment as voluntary liquidators. And these are provided for in Regulation 19 of the BVI Business Companies regulations as amended. All of those requirements there are cumulative, which means you have to satisfy all of those requirements, except in the circumstances where you're already an insolvency practitioner, you qualify, you don't need to demonstrate qualification in other areas, such as demonstrating that you have expertise or other professional qualification, either in the area of law or accountancy. So it's vice versa. If you have that, then you don't necessarily have to be you don't need to hold an insolvency practitioner's license in order to be appointed a voluntary liquidator. So like I said, it needs to be considered very carefully. All of those provisions in terms of qualifications, see for those two elements that I just outlined are cumulative and they must all be complied with. And also the Act provides for a legal framework whereby a voluntary liquidator will be required to collect and maintain certain records, particularly those relating to records required under Section 98 and 98A of the FSC, and 98A in particular, which deals with the annual returns. So those are important to be collected And also the FSC may request a voluntary liquidator to collect and maintain any particular record that the Commission considers is important. In addition to that, we've also amended the Act further to clarify the points at which the court may make an order terminating a liquidation, which essentially has to do with the process from appointment of a voluntary liquidator to the point of completion and providing a statement of or filing a statement of completion. At that point, it is only during that intervening period that an application may be made to terminate the appointment of a voluntary liquidator, not outside of that. This has been an issue. Our legal department has actually pointed out to us. It has been an issue because we thought we would make it much clearer in order to ensure that going forward, everybody's clear as to the period within which an application may be made to terminate the appointment of a voluntary liquidator. We have also effected amendments to sections 17, 17A, 17B, more 17A and 17B really. As you may be aware, or should be aware actually, under section 17 of the BVI Business Companies Act, provision is made in terms of the name endings that a company may carry. And those were envisaged in terms of companies that are engaged in commercial activity. We have provided some element of flexibility now, whereby you can actually have a name ending as outlined under section 17, but also engage in not only in commercial activity, but in non-commercial or charitable activity. So that is now permissible. You just have to comply with certain requirements in order to ensure that that is done. But you have to submit an application to the registrar, who will consider the application to give approval. In addition to that, once you are incorporated as such, there are certain obligations that arise, which you must ensure to comply with as best as possible. One of them, which is fundamental, is in the provision of financial statements. You must ensure that the business of the commercial aspect of the company and the non-commercial aspect or not charitable aspects are segregated, so that it becomes clear what aspects actually relate to the non-commercial or charitable activity. And you can also provide a consolidated financial statement, so long as it segregates the financial activities of each of the entities. And you can have one company, or you can have more than one company. Everything can be consolidated. You just need to ensure that that particular segregation of financial activity is very clearly spelled out. For the purposes of the retention of records and underlying documentation under section 98 of the Act, it is important that a company registered office remains what it is as at the date of completion of a one-off transaction or termination of a business relationship. In other words, this is considered fundamental. I know there has been, some disquiet about it in some quarters, but we have an obligation internationally to ensure that we are able to access records when a request is made, particularly on a mutual legal assistance basis. So at the date of termination of a relationship with a company, the registered office of that, if it is that of the office of the agent, then that is what it remains to be, continuing and ensuring that appropriate records are being maintained, so that the commissioner or competent authorities know when and where to source that information if a request is made or if it is necessary. Now, coming down to resignations of registered agents, that's another area where reforms have been carried out. Whereas in the past, there was a requirement to provide a notice of intent of resignation that which had to be 90 days. That has now been cut down to 60 days. So now you only need to provide 60 days notice of intent to resign. And at that point, the program begins to run, of course. If at the end of that period, a company does not appoint a new registered agent, or a registered agent that has provided a notice of intent to resign has not rescinded that notice, then it takes effect automatically. That is mean the resignation takes effect automatically. You no longer need as an agent to file a notice of resignation, which is what is required under the current regime. But what we are proposing now is that you no longer need that. It will be, the resignation or the notice of intent to resign will be deemed as completing the resignation period process after the 60-day period comes to an end. So that is as far as resignation is concerned. Let me come down to the whole issue of dissolution and the striking of companies. This is actually the precursor to everything that has come about with these reforms to the BVI business companies regime. Like I said before, we have the strike-off regime. Currently, if there's default warranting strike-off, you are struck off the register, and then you have a period of 7 years within which you can apply to restore. If you are dissolved, you have a period of up to 10 years within which you can apply to be restored to the register. All of these areas have now been reformed. Now, and this was outlined in the policy document that we wrote out. Obviously, it was a very difficult decision to arrive at, but we were pleased that at the end of the day, there was a general consensus on the approach to take on that subject matter. Now, what we have provided in terms of the striking of and dissolution is this. When a company is in a state where it has defaulted, whatever the reasons may be, as outlined under Section 213 of the BC Act, then the registrar is required to provide notice to the company concerned to regularize that particular default. And that period can be anywhere up to 90 days. That's a discretion vested in the registrar. Now, if the company complies, obviously it is not affected in terms of the struck of the register. But if it fails to comply, then the registrar has a legal obligations to strike the company of the company's name of the register. And then the striking of is followed automatically by dissolution. And the way it operates right now, or the way it is expected to operate come 1st January 2023, is that once a company is struck off the register, that striking off is published in the Gazette. And that publication triggers automatic dissolution by virtue of Section 216. So this is the new regime that has been put in place. But at the point at which a notice goes out to a company, since all of these go through the registered agents, the registered agent has an obligation to update all the necessary CDD and other information in relation to the company, if it already hasn't done so. If it has done so, well and good. But if it hasn't done so, the Act makes it very clear that the registered agent has an obligation to ensure that is done as quickly as possible, but no later than the notice period given to the company. in order to ensure that those records are available should the company be struck up and then automatically dissolved. Let me now move on to the issue of restoration. Pursuant to sections 217 and 218 of the BCR. 217 being the method by which you can make an application to the registrar to restore a company on the register, which we normally say restoration in normal way. And 218 is the mechanism by which you make an application to the High Court to be restored to the register. Those methods are still available. However, there are some differences in terms of how or what qualifies one to go under one as opposed to the other. But first of all, the struck-off period of 7 years has now been cut down to 5 years. And I will come later on to deal with the issue of the legacy companies, what happens to those ones that may be relying on the 7-year period, and also for the dissolved companies that may be relying on the 10-year period. I'll come down to those later on when I deal with the transitional provisions. But what is expected here is that if you want to be restored to the court, to the register, even if you are dissolved, you have 5 years within which you can apply to be restored to the register, either by the registrar or by the court. And it's important for you to take a look at those two sections as amended in terms of what qualifications apply. For instance, if you were carrying on business as at the date of striking of and dissolution, you can apply in the normal way to the registrar. But on the other hand, if you are not engaged in any business as at the date of striking of and dissolution, you can only apply to the High Court. So there are all of these nuances that have been provided. So it's important for practitioners to be aware of those in order to make a determination as to which particular process to apply. So that's in essence is what that has to that we have to ensure we comply with. And a company that is restored, for example, in liquidation, obviously continues in that mode, and at the end of the liquidation process has to file a statement of completion of liquidation. And it cannot engage in any other business. And the same rule applies where a receiver has been appointed. The other area where reforms have been carried out relates to the continuation of a company outside of the BVI. We know what the regime is currently. You file an application to the registrar, it is processed, and then and then you can continue outside of the BVI. There are new requirements now. If a company wishes to continue outside of the jurisdiction, it has to file. It has to notify its members and creditors, and it has to publish that notice of intent, a notice of intent in the Gazette. If it has a website, obviously on its website as well, and it has to give 14 days notice to ensure that that information is reached across the board. Those who have a legitimate right to contest that, should they wish, then they can do that. But that is important to know and to know. And then there is a requirement to then file, make a filing with the registrar of the notice of intent to continue outside of the BVI. And that notice will have to have certain declarations that, for example, creditors and members have been notified. There has been publication, there has been an advertisement in the Gazette and so on and so forth. And where a company has actually filed a notice of intent to continue outside of the jurisdiction, it has latitude still, before the registrar acts on that notice, to rescind that notice. So that mechanism is also provided as well. Moving on to the register of directors, we all know what is now. Every company is required to file a copy of its register of directors. Now, obviously, we have been having some issue with this particular subject matter. Obviously, the issue revolving around the FATF recommendation, which has to do with recommendation 10. Now, there is a requirement under those recommendations for certain basic information to be retained in the public registry, and that information should be publicly accessible. Right now, we comply with all those requirements except one, which is the one relating to directors that is provided in the list of directors. We discussed this back in 2016. It was a very difficult discussion. We hashed out an arrangement. We did not fully comply with the FATF standard, but through this dialogue this time around, we all thought it was really necessary that we carried out that reform. And what the reform in the BC Act actually provides relates to the requirement for a regime which allows for any person to make an application to the registrar to be provided a list of directors, not a copy of the directors. I think this distinction needs to be made very clear. It is only in relation to the list of directors, because that is what the FATF standards require, and we are not going beyond the standards in that particular regard. So if anybody makes an application to the registrar, pays the requisite fee, are requesting to be provided with a copy of a list of directors of any particular company, then that has to be provided, and that relates only to the current list of directors that is contained in the register of directors. Now, moving on to the financial returns or annual returns, I'll be using those interchangeably. Now, this again has to do with one of the global standards that we as a jurisdiction are required to comply with, and specifically the Global Forum, of which we are a part. And one of the requirements has to deal with the whole issue of ability of foreign entities, i.e. regulators and law enforcement agencies in tax-related areas, should be able to access certain information, i.e. accounting records and so on, whenever they are requested. Right now, we do not fully comply with that requirement. As it is, in fact, to be very frank, we do comply with the legal framework as outlined in the Global Forum standard. But when the jurisdiction was assessed a couple of years ago, and the regime was put to the test, we failed. The information, was located elsewhere. When it was requested, it couldn't be accessed, and so we ended up with having been given a recommendation to implement, which is to ensure that those records are being maintained within the jurisdiction. So effectively, what we have done is to introduce a new section, which is Section 98A, within the BVI Business Companies Act, whereby every company is required to file an annual return, and that filing is supposed to be done to the registered agent and not the registrar. During the consultation process, we did put out those options as to whether the financial returns should be filed with the registrar or with the commission or with the registered agent. The overwhelming opinion was that those records should be filed with the registered agent. So effectively, this is the way the regime is expected to operate. The regime is not expected to kick in terms of that reporting, that filing obligation until 2024. But that will be in relation to the year 2022. So which means the reporting period commences 9 months into 2024. That means by September 2024, every company should be providing its annual returns to the registered agent in the form of filing. And the registered agent has an obligation to ensure that any person who has failed to, that is any company that has failed to file its annual return, it notifies the registrar of that fact. Where no notification has been provided to the registrar, then the presumption is that the company concerned has fully complied. If it turns out eventually that in fact it has not complied, the registered agent is legally liable, and a penalty applies under the act, which will be enforced. In terms of the details of what should be provided, that is where the legal framework has been provided for the Commission to provide, to prescribe what should be contained in the financial statements or in the annual returns. We did roll out during the consultation process a draft BVI Business Companies Financial Returns Order 2022, on which we invited comments. We did receive numerous comments on the subject matter, but frankly speaking, we ourselves were not too certain as to which one to adopt because the views were very divergent. So we thought that we didn't need to rush this particular regime, considering that the reporting period is still way down the line. But nonetheless, it is one we need to iron out in order to ensure we put it in place so that all agents are aware of what the regime looks like. All companies are aware of what their obligations are in terms of those filing requirements. We hope to convene shortly a meeting with the leaders of all the various associations. Because we didn't see the need, we really don't see the need to invite everybody because we have the opinions already. So what we have done is to put those opinions together. So we will invite the leaders of the various stakeholders to a meeting so that we can put those issues across and see what we can do. The legal fraternity within the industry has been extremely active on this, and they provided us already what they think we should be doing in terms of dealing with that particular subject matter. It's a similar thing we will expect from other stakeholders, so that at the end of the day, when we do convene, we can ensure a very robust and meaningful dialogue on the subject, which will serve as a steer to the Commission in terms of the best way forward on that particular subject matter. And I should point out one thing in terms of the obligation on the registered agent to notify the registrar of any failure by a company to file its annual return within the due period. It has 30 days within which it must file. It must provide that notification to the registrar. Any failure to provide that notification outside of that 30-day period obviously will constitute an offense. And we certainly hope we won't get there with any registered agent at all, because for us, both at the Commission and at the registry, our preference is always to ensure that there is compliance as opposed to really imposing penalties or citing anybody for any particular offense being committed. There are, however, exceptions to these particular requirements in terms of the filing obligations of annual returns. If you're a listed company, or you're a company that is regulated by the Financial Services Commission, and you provide financial statements to the Commission, as you know, under the regulatory legislation, certain entities are required to provide annual financial statements. So if you fall within that category, or you file, you file your annual tax returns with the Inland Revenue Department, which is accompanied by financial statements. If you fall in any of those three categories, then you are exempted from providing an annual financial return. So it will be important that we bear those exemptions in mind, and those are elements that should in practice be notified to the registered agent, which will in turn notify the registrar. The registrar obviously will deal with the practical aspects of how that mechanism will work. And that she's already started working on that process, and so she can provide better guidance on that. Now, in terms of the filing process, obviously, consolidated accounts may be filed if they can show that, if they can show the activities in relation to each company. So there shouldn't be a particular issue in relation to that. Now, the period of reporting, what we've outlined in the Act is the financial year, all right, which is the calendar year, from January to December. However, if a company has a different financial year, fiscal year or financial year, then it is that fiscal or financial year that will apply in this case. So we've been very flexible here, whereas initially the proposal was just restricted to reporting for the calendar year. We moved away from that based on the opinions we received from the consultation, and provided a mechanism whereby if a company's fiscal year is different from a calendar year, then we start fiscal year that will apply. Then going on further on that same subject matter, we have made further provision that one of the conditions, if you look at section 235 of the BVI Business Companies Act, you can make an application to be provided with a certificate of good standing. For example, all the necessary requirements are outlined there, including being up to date with your filing of register or copy of your register of directors. We have now included filing your annual returns. Now, the registrar has to be satisfied that you have actually filed your annual annual financial returns, or they are not yet due, depending on the date of application of your of the certificate of good standing. One would consider that in a way as a presumption that if the registrar, if the registered agent hasn't notified the registrar that you have not filed your annual return, then the presumption is that you have filed, which means you are compliant. But obviously, to avoid delays in that process, what we've done is to clarify it better in the regulations, whereby the commission will come up with a short form, nothing complicated really, a simple short form pursuant to section 241, because the powers are given under section 241 to devise forms. So that form will effectively make it, outline it very clearly, name of the company, application being sought, and a declaration that it has filed its annual financial returns, and that's it, so it's going to be a very simple form that will be utilized, and that will facilitate the application process. So the registrar doesn't have to go back to check whether the particular company is compliant with regard to its filing obligations or not. So that is provided for in the regulations. That's just designed to ease the process of ensuring faster processing of applications for a certificate of good standing. Then if you fail to file your annual returns, what happens? Like I said earlier, you are liable to a penalty. The penalty is $300 for the first month or part thereof, during which you have not complied with that requirement. If after that 1 month period you continue to be non-compliant, then $200 penalty will apply for each month or per day that the non-compliance continues, to a maximum penalty of $5,000. So then what happens when you hit that maximum, when you hit that maximum $5,000 penalty? Then you will be liable. If at that point you still have not complied, you will be liable to be struck off the register pursuant to section 213 of the BVI Business Companies Act. Finally, coming down to the transitional provisions, and I'll try to be brief on this because the provisions are, in my view, self-explanatory. We've created a new Part 7 under the BVI Business Companies Act, which deals with how legacy companies will feature in this. And it is particularly important that you all look at the definitions of an existing struck-off company and an existing dissolved company. Because there is a stark difference as to how they are treated. The effective date begins 1st of January, and the periods begin to be calculated from then. Let me use an example. If you're an existing struck-off company, which means currently you're struck off the register, you have 7 years under the current regime, which is now being cut down to 5 years. But because we want to regularize all of this and put it in the proper perspective, and we are introducing a new regime of striking of automatic dissolution. If you are a struck-off company as at the date of coming into force of these amendments, you have a period of up to 6 months within which you can apply to be restored to the register. However, if your period of registration under the current regime would have come to an end earlier than 30th June, then it is that earlier period that will apply. Let's say under the current arrangements, you've been struck off the register and your 7-year period comes to an end on the 31st of March 2023. You do not have up to 30th June 2023 to apply for restoration. You have only up to 31st of March 2023 to apply for that restoration. If on the other hand, your period of—
Sorry, Mr. Jallo, you went a little quiet when you said that last sentence. So can you repeat that, please?
Okay, let me go back. Using as an example, if a company is struck off the register, and we know the 7-year rule applies right now, that is now being reduced to 5 years. You struck off the register as of the effective date, meaning as of 1st January 2023. You have 6 months within which ordinarily you can apply to be restored to the register. However, if your period of restoration under current arrangements were to come to an effect, let's say on the 31st of March 2023, it is that earlier period of 31st March that will apply. In other words, you have only up to 31st of March to apply to the restored register. If on the other hand, your period of restoration would have come into effect after the 30th of June 2023, you have only up to 30th of June within which you can apply to be restored to the register and not the later date. Because we are trying to streamline this to ensure that there is full compliance. A similar regime exists in relation to existing dissolved companies. There are 10 years, now it's 5 years. So you have 5 years within which you can apply to be restored to the register. And if your period of restoration is more than 5 years from the effective date, you have only 5 years. So which means 2023, you have only up to 2028, within which you can apply to be restored to the register from a dissolved status. So that mechanism is provided. That's why I say it is important that you all pay attention to the definitions of existing struck-off company and existing dissolved company. Where an existing struck-off company is not restored to the register within the prescribed period, then it will be deemed dissolved on the day following the end of the prescribed period. That means 1 day after the period that has been prescribed, the company will be deemed by operation of law to be dissolved. Consequently, a registered agent is also deemed to have resigned as agent of the existing structure company. That is, if the agent hasn't already resigned. So there is no need really in terms of the legacy company for a registered agent to file a notice of intent to resign. You can still do it, if you want to do that. But if you do not, if the company does not comply with the restoration obligation within this prescribed period, and it is then dissolved, the registered agent is, as a consequence, also deemed to have resigned as agent of that company. Obviously, that dissolution or that deeming obligation does not necessarily mean that the registered agent is not obligated to comply with its AML/CFT requirements. So it means, notwithstanding that a company is deemed to be dissolved, that's a legacy company deemed to be dissolved after the prescribed period, whatever legal obligation the registered agent has, for example, to put together and update CDD information, that's customer due diligence information, as required under the other laws, then it has that obligation still remains. And the advisable thing really is, once a company is in that status, the best thing a registered agent should do is to ensure that it has all the up-to-date information in relation to that company. We know there are practical challenges, but there are ways of going around those practical challenges. If you look at the AML safety code and the regulations, they squarely address those particular matters. Obviously, we can't predict what the courts can do. So notwithstanding the fact that we've been dissolved, the courts may, people may still make an application to the courts, and the court may make determinations or otherwise. But what we have provided for, in order to ensure that we do not continue to see a proliferation of these legacy companies that have been struck up and then dissolved, still lying in the books. We want to ensure that if there is an application to be restored after you've been dissolved and the court makes an order to that effect, a penalty of $5,000 will apply. And this is only in relation to where this application is made by a person other than a creditor, former director, et cetera, et cetera. These are all properly outlined in the BVI Business Companies Act. But I will encourage all participants to take a thorough look at Schedule 7A, which is the new schedule that has been added to the BVI Business Companies Act, in order to know how best to treat those legacy companies for which we still act as agent. The final point really has to do with a new provision which outlines new regulations that may be coming our way, in the future, which has to do with Section 230 of the BVI Business Companies Act. It provides for the legal framework for regulations to be made for a register of persons with significant control. And this is basically the publicly accessible register. The subject matter is really not that of the commission, it's that of the government. But obviously it deals with companies that the commission has responsibility for through the registry. And the framework properly falls within the BVI Business Companies regime. And that is why we felt it necessary to amend that particular section to provide the legal mechanism or the legal framework by which those regulations can be made. Obviously, I can't tell you when those regulations are to be made. That's a matter, like I said, that the government is working on. The commission is there practically in an advisory capacity, if I may say so. But essentially, it's driven. It is being driven by the government, and I'm sure at the appropriate time, obviously, there will be consultations that, just like we do with every other significant change to the BVI business companies regime. But if there are any questions on that, I'll be happy to look at them. So in essence, Madam Chair, these are just the highlights of the major areas I thought I would focus on, and I'll be happy to discuss them and to clarify any matter. There are practical aspects dealing with changes to Virgin. Mona is the one leading that process, and she may be able to speak on that better than I would. So if there are any questions, Mona, I don't know whether this is a good time to step in, but I'll leave it to the chair to continue steering the meeting forward. So thank you very much.
Okay, thank you very much for that presentation, Mr. Jallo. We've had a number of topics that you've covered that take effect essentially in January 2023. You spoke about the bearer shares, the elimination of that regime, and that was unanimously essentially agreed by all parties concerned. You spoke about the voluntary liquidations and what is going to be required in terms of having liquidators and the process for that. You spoke about the register of intent and in terms of filing outside of to move outside the jurisdiction, and the requirement to now file your intent for moving outside the jurisdiction. You spoke about the register of directors, and you made the distinction that it's not a list of companies, but a list of directors, and that the FSC would essentially make the requirement only what is required and not more than that. You also spoke about the ability of foreign entities and the requirement for accessing accounting records, and now the requirement for filing annual returns. And by September 2024, everyone will be required to comply with this requirement. There has been a legal framework that has been provided in terms of the financial returns. It is still being ironed out and will be essentially in rolled out shortly. But if you are in any of the categories, the 3 categories that are already required to file your annual returns, that requirement is not applicable. The financial year has been from January to December, but if you have a different financial year, of course, you will inform the commission so that you will remain in compliance. You spoke about the ability to Section 235, and the register has to be satisfied that you have filed, and whether or not you have filed correctly, and that if you are going to be filing later on. And then you also spoke about the existing struck off regime and the periods for that to be restored. And now that is I think that was a little complicated, so maybe there are questions which you may have to expound on that. But we certainly heard that there are several, deadlines, and 31st of March, 2023, 30th of June, 2023. And you have up until, I guess, 5 years to make sure that, that is done. I believe there are quite a number of questions in the chat. And so rather than continue to summarize what you said, I think it would be prudent to jump into the topics that we have in the Q&A. The first question we have, and I'm trying to make sure I'm getting them in the order of which they were asked. How will the RAs know that a company has been struck off, dissolved, if any time within the 90 days?
Yeah, the answer to that is pretty straightforward. Like I said, the registrar will issue a notice to that effect, that if you do not regularize your status within a period of 90 days, then you are liable to be struck off for the register. And as I said also, that striking off in terms of the publication triggers automatic dissolution. So when the notice goes through the agent, of course, so the agent will know. And the second thing is that there will be a publication, it will be in the Gazette. So the agent should know, because the Gazette is a notice to the whole world. So I think that's a fairly straightforward process, and the agent really should be in the know as far as that is concerned.
Okay, once a company is struck off, dissolved, that company will be visible to the agent which was in place at that time. The question is raised as there is a requirement for restoration that a licensed person to agree to act as registered agent. Not sure I understand. Once the company is struck off, dissolved, will that company still be visible to the agent which was in place at that time? I guess that's the question.
I'm trying to understand what it is, Mona, and feel free to jump in if this has to do more with what obtains in Virgin. But my understanding, if I can distill a little bit of it from the question, is, for example, a company is struck up and then dissolved. How would the agent know that? Is that's my understanding of the question, and it goes back to what I stated earlier to do in response to the first question. There is a notice which will be published. Striking the company of the register, and what every agent needs to know is that once that company is struck off the register and it is published in the Gazette, that triggers automatic dissolution. So there's no question in terms of what date about what date the company would have been dissolved. It is dissolved as of the date of publication of the striking of the name of the company of the register.
I think the other part of the question was if the company will still be visible to the existing registered agent. It will be, because they still have the option to apply for it to be restored to the register, even after it's dissolved.
Okay, yeah, because they have that 5-year period between which they can apply to restore it. Yes, absolutely.
So they have their 5-year period for it to be restored. So yes, it will still be visible. That's what you're saying. For
Yes.
companies that have already been issued a notice of intent for resignation as a registered agent, and the final notice is due to be filed after 1st January 2023 on the expiry of 90 days, will Virgin still be able to accept this filing?
Mona, you want to go on that?
I'm trying to clarify the question. If Virgin will be able to accept the filing of, is it the notice of resignation? Is that what the question is asking?
Yes.
From what I understand, the intent to resign was filed prior to January 2023. And the question is whether the notice of resignation is to be filed. Is that what the question is asking? Oh.
The question.
Let me take the first part, Elise. If I understand the question well, say a notice of intent to resign was filed in November, just as random. And under the current regime, that takes 90 days for the company to find a new registered agent, at the end of which, if no new registered agent is identified, the existing registered agent can then file a notice of resignation. That process under the current regime continues to its logical conclusion. So it's not like the 60-day period will apply or anything like that. You file this year, then whatever is dealt with this year continues to be dealt with as if the new regime hasn't kicked in. So that process will have to continue. So I don't know, Mona, I know you're working on the Virgin component of this, but I believe it should be along the same lines.
Yes, wherever the process continues under the previous regime before the amendments, the capability will be there for it to be filed based on the requirements that it started with.
For companies that are in penalty and about to be struck off for non-payment, will the registry be giving the company the 90 days notice after the 50% penalty that is in effect? Will the company have an additional 90 days before it is struck off?
Similar to the intent to resign, where the process was started prior to 2023, it will continue with the process that it was started with, and it will not get an additional 90 days before it is struck off.
We have a what they're calling a layman's question. The BVI Business Companies Amendment Act 2022 is an act to amend the BVI Business Companies Act Revised Edition 2020. What is the BVI Business Companies Act Revised Edition 2020? Previous amendments have been to the BVI Business Companies Act as amended.
All right. Yeah, maybe this needs explanation. It is just a drafting formula that the Office of the Attorney General has recently adopted. You will recall that all the financial services legislation went through a revision exercise as up to January 2020. So the new drafting formula adopted by this office is that any reference to any financial services legislation, at the end of it, we put 2020 revised edition. So we know exactly what text is being referred to. The idea being that as we go along and as we have amendments to various financial services legislation, we should be able to undertake another revision and update that and then make reference to the year of that revision. So at any point in time is the final, is the most up-to-date revision we are referring to, so to avoid confusion. That's my understanding of the rationale for the AG's office putting this process forward. The reference to, before BVI Business Companies, as an example, as amended, obviously it's nothing cast in any particular law, but in the practice we say as amended. But once an amendment goes through legally, it forms part of the substantive legislation. You don't necessarily need to make reference to as amended, unless you want to do that in order to establish the period when that particular measure was brought in as part of the law within the particular regime. So it's just a technical issue that really doesn't affect anything.
We have quite a number of questions and we probably won't be able to get through all the questions. So the commission will make available, I guess, a Q&A after this session. but we'll try to get through as many as possible. How would the registrar?
Perhaps what I can say, Elise, on that is that the registry headed by the registrar is currently working on FAQs, and this will be finalized and rolled out to the industry before the end of the year. I think the plan is to do it as early as possible within the little time frame we have before the end of the year, but that is being worked on. That will incorporate as many of the questions as possible. Where the questions can be amalgamated because they are related or deal with the same subject matter, that will be done, and then appropriate guidance will be provided.
Okay. How would the registrar determine if an registered agent is being truthful in declaring the annual return was filed when filling out the short form in connection with the CGS application?
That should not be a concern for the registrar, frankly speaking, because you be honest or dishonest at your own peril, or you be dishonest at your own peril. There are consequences for not representing the truth. The law makes specific provision for that, and that's not an area we hope we will see any failing at all. If you take, for example, the financial returns, those are required to be made by companies to the registered agent. The registered agent's obligation is to notify the registrar if any company for which it acts as agent fails to comply with that requirement. If an agent doesn't do that, then the agent is obviously liable. And it comes down to a lot of other potential consequences, which we hope certainly will apply insofar as the agent is concerned. But remember, the agent is a regulated person. And that has, that might go to the fitness and propriety of the agent, and a host of other issues. So, like I said, there are consequences for not complying with the law or trying to cheat the law, and we certainly hope that is not going to be practice we will see occurring.
A follow-up to the previous question, Mr. Jallo, when will the Consolidated Act be published? I guess that's a question for the AG, or can you answer that?
The Consolidated Act has actually been published, the 2020 edition. That's what we use. It is available. We got our copy from the AG's chambers. So that is already published. It's been laid in the House and it's been published to the Gazette. Obviously, since
the substantial 2022 amendments, I think that
I'm coming to that. I'm coming to that. That is a matter that obviously will be up to the AG. I don't expect that it will be anytime soon, because maybe in the next couple of years, we'll have other series of amendments to the BVI Business Companies Act. But again, this is a matter I will leave entirely perhaps to the MD, who normally coordinates on these matters with the AG's office. But if it is considered feasible, considering the numerous amendments that have been made to do another consolidation, obviously that will be done. The problem with our industry is that it's a moving industry. And as the industry moves, legislative changes are effected. And there will always be those changes. So one wants to wait until you have until a fair period has elapsed, when there would have been more than one amendment, so you can consolidate all of them. Because remember, all these revisions and consolidations, they cost money. They don't come free. The commission actually pays for, subsidizes. Ken will be better able to tell me which is which, for these services, and they're not cheap. But we do understand why the question is being asked, because it's easier to have a consolidated text before you. You have the most up-to-date text you're working with. Reading amendments into the actual text can be a nightmare at times. So I understand that perfectly well. So something perhaps the commission might want to consider.
Is a registered agent deemed to have resigned on the date that a struck-off company is dissolved in the same way that the registered agent is deemed to have resigned for an existing struck-off company that is not restored by June 2023 under the transition period.
As I said, if I believe I've answered that in my submission, in my highlights earlier. If an existing company does not comply with the requirement to restore as at the prescribed period, whether be it an earlier date or 30th of June, it will be automatically dissolved, which means it will be deemed dissolved. That is for a structure company to be deemed dissolved. And by virtue of that dissolution, the registered agent of the company, if it has not resigned earlier, will also be deemed to have resigned. So there is nothing, no particular action the registered agent needs to take. By the operation of law, the agent is deemed to have resigned.
Okay, this person is asking for clarification, not sure if they heard clearly, but their suggestion is for annual return declaration to be made by the registered agent while paid annual license fees, so it can be incorporated as one. So the registrar will automatically know that the annual return fee is paid and that the return has been filed.
I'm not sure I understand what it is. I guess that is a,
They're making a suggestion.
A suggestion, okay. They're making a suggestion, but I'm more concerned about what the law is and how it is designed to be implemented as it is now. Remember, we had put out options for the filing of annual returns directly with the registrar. That wasn't a popular suggestion. So the suggestion that eventually carried the day was that the filings should be made, every company should make its filings of annual returns to the agent. And the only obligation on the agent there is to report to the registrar any company that hasn't made such annual filings. That's all it is. In terms of the fees they collect as a result, that has nothing to do with the registry or the commission. If opinion changes subsequently, I mean, in due course, that filings should be made with the registry, we'll be more than happy to consider that. But obviously, you know, there will be whole issue of fees as well. So
I think it's a good.
Going to be a simple, straightforward matter.
Yeah, I think it's a good suggestion if it was straightforward, the filing with the registered agent, because it depends on the company's financial year as well as depending on the time that they file the annual return. So I don't think at this point we can pinpoint it to when they file the annual fees because of the requirement of the Act.
Okay.
But,
just moving on quickly, could you clarify the updated registry fee schedule as it relates to Section 233 and whether the previous Section 233 for inspecting the records on the register of companies relating to a company or on the register of foreign companies relating to a foreign company, A, where the inspection takes place at the office of the registrar, whether the inspection is of electronic or paper records, and B, in any other case, is replaced with for the inspection of A, registers maintained by the register under Section 231, and B, any other qualifying document retained by the registrar in accordance with Section 234, subsection 4, seeking to determine whether the company's search fee would increase from $30 to $100 effective 1st January 2023.
Yeah, incidentally, this is something I've been discussing with Mona from last night. I have indicated to Mona this morning that I will, we will need to revisit that particular section just to put it beyond doubt as to exactly what is being referenced.
Mr. Jallo, a little volume, sorry, because you went down, so I didn't.
No, what I was saying is, yes, Mona and I have been having, exchange on this particular section and the fees, and we've agreed to take another look at it. But currently, the requirement, the fee applicable for searches is $50. That's very clear from the schedule. But in terms of the other aspect, because the initial intent was that if you want to do the search within the registry, then you apply $30. But obviously, under the new regime, any search, any inspection of the register is $50. So you can, we will provide clearer answers on this, because I think there's something off on it, I have to admit, and I've indicated to the registrar we will have that discussion to clarify it as quickly as possible.
Mr. Jallo, this is a question that helps us all. How would you alleviate the anxiety of clients and overseas officers who are of the view that the changes and the increased fees would reduce the number of incorporations and consider incorporating elsewhere?
Well, the fact of the matter is, if we take a comparison of what obtains elsewhere, the BVI is still considered cheap jurisdiction, if I can put that in inverted commas. We
cost effective. We use the word cost effective, please.
Well, I just want to be blunt about it. We do not always, in a very regular way, amend our fee schedule. I mean, it takes a while. We take inflation into account and many other factors into account to ensure that we are being fair. And that is something we do consistently across the board from time to time. Obviously, there is always a choice for people, and there's not much we can do about that. But we think agents need to be aware that we do provide a regime that is flexible, investment friendly, and so on and so forth. And it is really more for the industry and BVI Finance to really make clients aware that we still provide quality service as a jurisdiction, one that is robust, one that is efficient, and one that is effective. And efficiency obviously comes at a cost, and as technology requirements, escalate, so we also need to keep up to speed. The Virgin system we are now revamping basically costs a lot of money. And these fee increases are not going to cover that. They can't cover that. So it is an exercise that we necessarily need to carry out. We do it every 5 to 7 years, or maybe 8 years. And in between, we may carry out some amendments because they are of an urgent nature and considered necessary. But we at the Commission can only assure the industry that we continue to be very modest in our fee increases, taking other global currents into account, and also what obtains in other jurisdictions. And it's really more for the industry players and BVI Finance to assure them, to assure clients that we continue to be that quality jurisdiction where we provide these services at an efficient and effective rate, which comes at a cost. And it's important that we try to alleviate that to some extent.
Okay, in respect of the, I'm sorry, Marna, you were going to say something else? Or Mr. Baker? Okay. In respect of the request for the list of directors, how practically would this be made by any person?
How practically would what?
This be made by any person making a request for the list of directors?
Well, like I said, it's really open. Anybody can make the request. There is a fee that you must pay. I think it's $75 under Schedule 1, and there are requirements that you must comply with. But it is an open process, and you can only receive a list and not a copy of the register. As you all know, the copy of the register has a lot more detailed information, which they are not required to have because it is not required under the standards. We use it for our own purposes, but it's important that whoever makes that application, it has to be in writing, of course, and that application reaches the registrar. And the fee is paid, the registrar has to make the information available because that's what the standards require. There is no intention to put a restriction on that.
And if I may add, the request can be made similar to how certifications are made or any documents that are on the register. So it can be made locally and internationally in the same way that you would request any document that's on the register of companies. And to reiterate what Mr. Jallo said, it will only be the list of the names of directors, of the current directors, and not the full director information. So it is quite practical for it to be done.
Okay. What financial period is expected to be the first reporting period? Are those the financial periods starting in 2023 or financial periods ending in 2023? Example, a company with financial year running from 1st April to 31st March, is that company to first report by 31st December 2023 or by 31st December 2024?
Like I said, using the calendar is the easiest, but if you have a different fiscal year, like the example you've used, let's say a company's financial year begins in March, ends the following March, which is 2024. The reporting period begins in respect of the year 2023, which means your year is covered. All right. So your reporting period will be from March to the following year, March, meaning 2024. But whereas the one with the calendar year has up to September to provide that report, the one with the fiscal year ending in March 2023 has up to December. I hope I get my maths right. September, October, November, yes, has up to December 2024 to report. So that's essentially how it will apply in practice.
In respect to the annual return and the filing of consolidated accounts, it was discussed that it would be acceptable to file these provided that they show the activities of the company. Does this mean that the registered agent needs to make a determination as to whether these accounts satisfy this requirement from an accounting perspective?
Yes, in the case of consolidated filing, obviously it can be, you just need to demonstrate that the accounts of the various companies that have been consolidated in the financial statement, for instance, or the annual return is segregated and clearly made. Nothing more is really required of the registered agent at this point. This is something we've been discussing internally as well, because there will be the issue of verification at some point. We are not dealing with it at this point in time, which would have been better dealt with if the filings were made straight to the registrar. But at this point in time, we are not placing any verification obligations on the agents. The agent's obligation is to know its client. And by that, in this context, I mean, it needs to know that, for example, in a consolidated filing of accounts, the companies that are outlined there, in fact, companies for which it acts as agent, and the accounts are properly segregated. Once that is done, that's all that needs. There is nothing further the agent needs to do. The only area where the agent is obligated to carry out further work is if that consolidation leaves out a particular company that falls within the same context, within the same realm, the same group of companies, and there hasn't been any separate filing, then it has to notify the registrar of that filing.
Could a company which has been struck off and dissolved automatically in accordance with the new regulation obtain a certificate of dissolution once the process is completed?
Mona? The practical issue. I mean, once you
The legislation doesn't provide for it.
What normally happens right now, if a company is dissolved, Mona, you issue them a certificate of dissolution?
No, we don't. The only certificate of dissolution are only issued for voluntary liquidations.
Well, the same rule will continue to apply.
Same rule will continue. For automatic dissolution, there's no requirement to issue a certificate of dissolution.
Regarding companies not paying annual license fee by 30th November and not remedying their status during the penalty period up to 30th April, what will happen on 1st May? Will the notice to strike off and dissolve be issued 90 days in advance of the end of the old penalty period, or after the end of the old penalty period? What will be the status of the company during this 90-day period?
Mona, we've been discussing this, so perhaps you can take the lead on it.
Yeah, I think this is similar to a question that was asked previously, where the process began prior to January 1st, 2023. And if the company is in penalty, the 30-day period would still apply as under the old regime because the process started prior to 2023, so it will continue. I think it's similar to the question which asked if they will get an additional 90 days, and the transitional provisions does not provide for that, so it will continue as it did under the old act before the amendments. If I understand the question correctly.
In other words, there is no additional period outside of what is statutorily provided in relation to the entity or the company that commenced the process prior to 2023. That's essentially what it is.
Will voluntary liquidators appointed before 1st January 2023 remain appointed as sole voluntary liquidator if not meeting the professional requirements, Regulation 19? In other words, will the exemption under Section 2, subsection 4, which seems aimed at BVI residents' requirement, also apply to the requirements under the Regulation 19?
If you are appointed a voluntary liquidator of a company prior to 2023, you continue under the existing regime. The additional qualifications outlined in the new regime and everything don't apply. You are recognized as a voluntary liquidator because you've already been appointed as such. So you continue right up to the period of completion and filing of the statement of completion of liquidation.
Will monitor if voluntary liquidators appointed after 1st January 2023 meet BVI residents' requirement and Regulation 19 requirements, if at all?
Well, there is a requirement you must meet before you can be appointed. And once that is in place, obviously, it's very easy, very small community. And we've made these discoveries in the past. If you're a resident outside of the jurisdiction, consistently, outside of the required period, then obviously your appointment is liable to revocation. So I don't see any practical issue there. The commission does have its own monitoring mechanisms, either through the inspection process or some other mechanism. But remember that once a voluntary liquidator is appointed, there is a process that the voluntary liquidator must follow. There are legal obligations in terms of reporting to the commission with respect to particular records, particularly if it relates to to a regulated person. And now we've added a provision that if it is in relation to a regulated person, those records have to be notified as well. So it is important that all of those are taken into account. So that there are different mechanisms, there are different methods by which all of this can be easily detected as a matter of practice.
There's a question, will the agency, the company under its list? I'm not sure. Move on. For the new certificate of good standing request to include the confirmation of filing of the annual return, how would this be submitted by the company? Would this be made through Virgin? And if so, does that mean that only the registered agent of a company can make that request, or would a law firm still be able to request a certificate of good standing on any company?
Right now, in terms of the certificate of good standing, whoever has responsibility or has power under the Act pursuant to Section 235 of the BC Act can make that application for a certificate of good standing. The only thing, like I said before, is obviously there will be a form that will be devised in terms of providing the necessary information for the registrar to review and satisfy herself that all the requirements to secure a certificate of good standing have been provided or have been complied with.
Does an RA have up until 59 days to rescind its notice before the Virgin did not allow rescinding after a certain time prior to the 90 days?
Well, the period of rescission is there. You can rescind it before the striking of kicks in. There is that requirement there. In terms of how this will operate on the Virgin, I would think that that will be taken into account, but Mona, you might want to dilate on that.
Is it the notice of intent to resign?
This is the notice of intent to resign. You know, you have 60 days that is provided. And obviously that goes with that is on the basis, that could be that, it could also be the registrar's notice. But in time, no, it's the notice of intent to resign. There is provision that you can rescind that notice before the expiry of the notice.
And it's within 14 days before the end of the expiry of the notice.
Okay.
So it's the same as it was before. It's just that the time period is shortened because instead of within 14 days prior to the 90-day period, it's 14 days prior to the 60-day period.
Yeah, there goes your answer, Elise.
Okay, I think the previous question was answered. During that 5-year period prior to dissolution, are RAs required to conduct any AML CFT requirements such as ongoing screening, etc.?
The requirement under the AML laws is that once a company is struck off the register, you need to update your information. And frankly speaking, you need to be updating your AML CFT CDD obligations on a regular and a consistent basis. You need to be doing that. You don't really need to wait for some action to occur. But the requirement under the law is that once a company is struck off the register, you need to carry that update. In fact, once I would, the practical thing to do and the prudent thing to do, I should say, is that once a notice is issued to a company that it needs to comply with certain requirements, failing which it will be struck off the register, the registered agency needs to commence the process of updating the information if it already doesn't have that updated information. So that at the point when the company is struck off, the RA already has that updated information to keep.
Okay, the FSC had only allotted us an hour and a half, but we are taking an extra half an hour with their permission, of course. So that means we have 15 minutes left for us to wind up. Is that okay, Mr. Baker, Mr.